This is Constitutional Rights in Black and White.
There are 9 justices on the U.S. Supreme Court. In general, the court creates precedent only when most justices endorse a single rule of decision, typically by publishing a majority opinion. When the justices disagree over how to decide a case, the rule is that the majority rules. At least 5 justices have to agree before a binding precedent will be set. Or, as the court itself puts it, precedent can arise when there is a single rationale explaining the result that enjoys the assent of 5 justices. In many cases, however, 5 justices will not agree, at least not completely. Sometimes only 3 or 4, a so-called plurality, will agree on the rationale for the case. The other justices might agree with the outcome, but not the rationale, or they might agree with some but not all of the plurality's reasoning. Still, other justices will disagree completely and dissent. In such cases, there is no clear majority of 5 justices setting precedent. Instead, there is a jumble of different written opinions, each with its own rationale, each arguing for a different way to decide the case. What happens then? Or, more concretely, what are lower courts supposed to do in the face of this jumble of non-majority opinions? The current answer is the Marks Rule. In 1973, Stanley Marks was the manager of a Kentucky adult theater that screened X-rated films. He was prosecuted for transporting obscene materials in interstate commerce in violation of federal law. At the time, First Amendment law regarding pornography was governed by the Supreme Court case Memoirs v. Massachusetts. While Mr. Marks was waiting to go to trial, however, the Supreme Court decided a new case, Miller v. California, that provided less constitutional protection to pornography and therefore made it worse for Mr. Marks. Mr. Marks was convicted under that new, less protective Miller standard. His case went to the Supreme Court, where he argued that he should have gotten the benefit of the original Memoirs standard and that new, less protective Miller standard could not be applied to him retroactively. Yes, agreed the court. Miller cannot be applied retroactively. The Due Process Clause precludes the application of the standards announced in Miller to the extent that those standards may impose criminal liability for conduct not punishable under Memoirs. Ahem, said the Sixth Circuit Court of Appeals, who originally decided the case. Memoirs was a mess. There was no majority opinion. The standard in that case only got the votes of 3 justices, so we figured that Memoirs never really became binding at all. No, said the Supreme Court. That's not how precedent works. When a fragmented court decides a case and no single rationale explaining the result enjoys the assent of 5 justices, the holding of the court may be viewed as that position taken by those members who concurred in the judgments on the narrowest grounds. The 3 justices in the Memoirs plurality took the narrowest position, while 2 other justices concurred on broader grounds. 3 plus 2 is 5. Memoirs, therefore, was the law, which means that Mr. Marks was entitled to its protection. This is new and kind of disturbing, said some commentators. Usually we require a majority of justices to decide cases and create binding precedent. What authority is the court relying on for this weird rule about non-majority opinions? Actually, said the court, 3 of us said the exact same thing just last year in Gregg v. Georgia. We had to interpret an earlier case, Furman, which had only a plurality for its lead opinion, and 3 of us agreed that the Furman plurality had precedential weight because it rested on the narrowest grounds. We're following the same principle here. This sounds like bootstrapping, said the commentators. So the court is saying that this new rule, let's call it the Marks Rule, that gives precedential weight to a 3-justice non-majority plurality, is itself based on a non-majority plurality decision that itself relied on a non-majority plurality decision? Basically, yes, said the court. The Marks Rule has caused all sorts of trouble. It's confusing. Even the Supreme Court has admitted that it is hard to say what the narrowest grounds are for any given decision. It creates legal chaos because it's a hard rule to apply and lower courts can't agree on what the rule means. And most fundamentally, it destabilizes the decision-making of the Supreme Court itself. The Marks Rule undermines the principle of majority rule, and it encourages justices to splinter over large legal questions. And sometimes it produces absurd results. In a 4-1-4 split, for instance, a single concurring justice can change the outcome and significance of a case unilaterally, even when 8 other justices completely disagree with them. All they have to do is decide the case narrowly. I know the Marks Rule might seem kind of wonky, a technical matter that only a lawyer would care about, but it actually goes to the very heart of our constitutional democracy and the meaning of the rule of law. Setting legal precedent is very literally the Supreme Court's job. Precedent tells us what the law actually is, and it tells lower courts how they should decide hundreds of cases every year. That job of deciding precedent tends to be the most difficult and rife with disagreement, the more controversial and important the legal question becomes. In other words, in the very places where clarity is most valuable. And clarity is expensive. Supreme Court decisions have split in precisely this jumbled, non-majoritarian way over abortion, affirmative action, and the death penalty. The Marx rule makes this jumble worse. Okay, let's read the cases. The case Marx versus United States was not originally about the Marx rule at all. It was about the First Amendment standard that applies to obscene materials. While Stanley Marx was showing pornographic films in his Kentucky theater, his First Amendment protections were governed by Memoirs v. Massachusetts. After he was prosecuted, and while he was awaiting trial, the Supreme Court decided Miller v. California, which offered less First Amendment protection. Marx argued that he was entitled to the stronger protections of Memoirs, and that the retroactive application of Miller violated principles of ex post facto. The Supreme Court agreed, and for a long time, everybody thought that the Marx case was about those weighty First Amendment and ex post facto doctrines. Along the way, however, the Marx court had to decide how to handle Memoirs. The Memoirs decision was fractured. The obscenity standard was contained in the opinion of a three-justice plurality. When the Sixth Circuit upheld Stanley Marx's conviction, it basically ignored Memoirs, reasoning that the three-justice plurality did not have the binding effect of a majority opinion. It was in this context that the Supreme Court gave us what we now know as the Marx rule. When a fragmented court decides a case and no single rationale explaining the result enjoys the assent of 5 justices, the holding of the court may be viewed as that position taken by those members who concurred in the judgments on the narrowest grounds. The upshot of this rule in the Marx case was that Memoirs had binding precedential effect. The court explained that the three-justice plurality had decided Memoirs on relatively narrow grounds, while 2 others, Justice Black and Justice Douglas, concurred on broader grounds in reversing the judgment. Accordingly, the view of the Memoirs plurality therefore constituted the holding of the court and provided the governing standards. It took about a decade for the Marx rule to, well, start leaving its mark. Today, the Supreme Court regularly relies on the Marx rule once every 5 years or so, but not without some controversy and confusion. In a few cases, the court has expressly avoided using it, explaining that the rule is more easily stated than applied, and that it is not useful to pursue the Marx inquiry to the utmost logical possibility when it has so obviously baffled and divided the lower courts. Lower courts apply the rule pretty often, generating all sorts of inconsistent approaches and outcomes. The confusion caused by the Marx rule came to a head in the 2018 case Hughes versus United States. Hughes required the court to grapple with its own highly fragmented decision in 2011, Freeman. Freeman was about plea bargaining and the federal sentencing guidelines, an important and complicated question that affected thousands of criminal defendants. As the Hughes court explained, no single interpretation or rationale in Freeman commanded a majority of the court. The Freeman court had split dramatically 4-1-4. The 4-justice plurality had concluded that the defendant was eligible for a sentence reduction, and Justice Sotomayor wrote a concurrence agreeing with that outcome, but for very different, narrower reasons. 4 justices dissented. Most courts applying Marx to Freeman concluded that Justice Sotomayor's solo concurrence in the judgment should control because it was decided on the narrowest grounds. Yet the other 8 justices in Freeman had thoroughly criticized Justice Sotomayor's position as erroneous and arbitrary. Under the Marx rule, in other words, the court's least popular view had become law. The Supreme Court granted certiorari in Hughes to resolve once and for all how the Marx rule should work. Specifically, it granted cert on 2 questions. Whether this court's decision in Marx means that the concurring opinion in a 4-1-4 decision represents the holding of the court where neither the plurality's reasoning nor the concurrence's reasoning is a logical subset of the other, and whether, under Marx, the lower courts are bound by the 4-justice plurality opinion in Freeman, or instead by Justice Sotomayor's separate concurring opinion with which all 8 other justices disagreed. Full disclosure, I do not like the Marx rule. At oral argument, the lawyers and justices discussed an amicus brief that I submitted, as well as an article I wrote for the Harvard Law Review, in which I argued that the court should get rid of the Marx rule altogether. Here are some excerpts from what they said.
Professor Ray wrote an interesting amicus brief in this case, and arguing that the logical subset approach is illogical. And I think there might be something to that. Let me give you this example. Let's say that 9 people are deciding which movie to go and see, and 4 of them want to see romantic comedy, and 2 of them want to see a romantic comedy in French, and 4 of them want to see a mystery. Now, are the 2 who want to see the romantic comedy in French, is that a logical subset of those who want to see a romantic comedy?
I can't speak to romantic comedies in French, but there are a couple of this Court's precedents under which, contrary to what Professor Ray has said, logical subsets do in fact make a great deal of sense, if not all the time, then nearly all the time.
Why is the confusion necessarily so evil? And even if there's some confusion, there is some predictability that's going on. Under the Ray test, there isn't any. It's as if the decision was made and nothing has happened because we're still sending it back for the lower courts to be without real guidance.
I think the strength of Professor Ray's view, Justice Sotomayor, is that the current situation is not, in fact, providing much, if any, guidance. And at pages 16 to 17 of his amicus brief and in the underlying paper, he lays out innumerable circuit splits that have resulted from efforts to attempt to apply the Marx rule.
No, I understand you'd like us to decide what we're calling the Marx question rather than just resolving what Freeman means. But to what extent is the Marx problem real outside of the Freeman context? I know Freeman has beset the lower courts with a lot of difficulty and generated disagreements. But have there been real problems outside of that context?
Didn't the commentary that's been referred to, Ray and the other one, give lots of examples?
I think the Professor Ray's brief I take to
Not the
indicate
brief, the long article.
Yes, I take him to have identified cases where he asserts that there's been difficulty applying Marx in the past. So perhaps that supports the idea that there is benefit to be had from clarifying what the Marx rule means.
As best you interpret the Ray brief and the Ray article, is it your position, or would it be your position, that overruling Marx would be disruptive?
I think so, Your Honor. I mean, the Ray article points out that courts of appeals have relied on Marx quite a lot. There are over 400 decisions of courts of appeals applying Marx to over 100 decisions of this court over a 40-year period. So we think there's quite a lot of appellate court jurisprudence that's based on applying Marx to this court's decisions. So we think it would be quite disruptive to overrule Marx.
After all that, the Supreme Court decided not to decide the Marx question at all. As it wrote, a majority of the court in the instant case now can resolve the sentencing issue on its merits, so it will be unnecessary to consider questions 1 and 2, despite the extensive briefing and careful argument the parties presented to the court concerning the proper application of Marx. Which means that the Marx rule is still out there. The Marx rule has become increasingly salient in the federal courts of appeals. By 2017, the Marx rule has appeared in over 400 Federal Circuit opinions and had been applied to over 100 different fragmented decisions by the Supreme Court, often with inconsistent formulas. Some courts use the narrowest ground test, while other courts ask whether the concurring opinion is a logical subset of the plurality. State courts use the Marx rule even more often. The Marx rule, with its tolerance for non-majority precedent, has shown instability in some of the most important areas of American jurisprudence. For example, the 1978 Bakke case on affirmative action was a split decision in which Justice Powell's lone concurrence created confusion in the lower courts for decades. In 1992, the justices in Planned Parenthood v. Casey split over abortion. And as we saw in Gregg v. Georgia, the court has split multiple times over the constitutionality of the death penalty. Because of the Marx rule, lower courts have had to speculate about how to handle these enormous questions. This uncertainty is bad for the rule of law, and it's also bad for the administration of our system of vertical stare decisis. It forces lower courts to guess at precedent rather than providing clarity and guidance. It invites speculation, uncertainty, and error. That's why I argued to the Supreme Court in Hughes that the Marx rule should be abandoned. Instead of haggling over the narrowest grounds or logical subset, courts should simply follow the normal majority rule for precedent formation. They should ask whether a single rule of decision has the express support of at least 5 justices. If it doesn't, then no precedent should be created at all. The same reasoning suggests that unexplained summary rulings should also lack precedential effect, such as those that issue from the court's emergency or so-called shadow docket. This traditional approach places the burden of precedent formation right where it belongs, with the justices of the Supreme Court. At the end of the day, the Marx rule is unnecessary. The justices have plenty of tools at their disposal to resolve disagreement. They can deploy their individual votes to promote imperfect but acceptable outcomes and rules. Together, they can craft compromise majority opinions, or they can just wait before they decide. They might wait for better information or for more guidance from lower courts. The Marx rule gets in the way of these more sensible options. And so, in this context, the rule of law actually calls for one less rule.
Many thanks to my colleague, Professor Richard Ray. He is professor of law at Harvard Law School and a leading scholar on constitutional law, federal courts, and criminal procedure. He has received numerous awards for his teaching, and he appears regularly in the national media. He also maintains his own blog, Ray's Judicata. We're grateful that he took the time to share his insights with us.